Hey patent friends, I'm going to be giving a talk at the King County Bar Association here in Seattle, and I wanted to record a video of my practice run for this because it has some good information that is important for inventors, entrepreneurs, and startups. The talk is actually called Intro to Patents for Non-Patent Attorneys, but it's actually really relevant to a lot of folks, not necessarily just attorneys or especially non-patent attorneys. So they didn't let me actually record the actual presentation. They're keeping that one as proprietary channel content for themselves. So I figured I would record this practice run for you. So for those of you who are new here, my name is Dylan Adams. I'm a patent attorney, and I'm the author of the best-selling book, Patents Demystified, which is an insider's guide to protecting ideas and inventions used by inventors, entrepreneurs, and startups worldwide, including at top universities like Harvard, Stanford, and MIT. You might also recognize me from my appearance on CNBC's hit show, The Profit, with Marcus Lemonis. So this channel, typically I have smaller videos, ranging from say like 5, 10 to 20 minutes. This one's going to be a bit longer since it's a talk that I'm actually doing, helping people get CLE credit for attorneys. But yeah, check out the rest of the channel and be sure to subscribe for more on patents and startups. This channel typically gives you information, all the insider stuff that I use with my clients on a daily basis, whether they be Fortune 100 companies, Shark Tank companies, or startups. So all right, let's go ahead and get right into it. So what are we going to be talking about in this video? So we're going to give you an overview of patents and the patent process, and specifically like how patents relate to other sorts of intellectual property. That's kind of an important place to start. Patents are one type of intellectual property, and it's good to know where patents fit in with those other types. Also, why should you even care about patents? I think people realize that patents are important, but surprisingly, there's a lot of reasons why you should care about patents that aren't necessarily intuitive. And then also for those attorneys out there, how to counsel clients on patents. And for those of you who are clients yourselves, that being, if you're an inventor, entrepreneur, or startup, it'll kind of give you a sense of, how to understand patents yourself. So also understanding what a patent covers. People look at the drawings, they look at the description, they assume that that's what covered. That's actually not the case. And this video is going to show you, what actually is covered by patents and how to determine that. Not always understood by people. This video is going to kind of give you the answers on that as well. And then also the patent filing and examination process is going to give you the whole layout of that, and also discuss the important distinction between patentability and infringement. A lot of people use those words interchangeably. There's a really important distinction between those words, and this video is going to give you that as well. Okay, so like I said, my name is Dylan Adams. I am a partner and I'm a patent attorney at the firm of Davis Wright Tremaine. And it's kind of helpful to step back and sort of get a sense of like, okay, what do I do as a patent attorney? What is my job really like? And that kind of informs the patent process. One of the things is, I have a focus in patent prosecution, which sounds like litigation, but what patent prosecution actually is, it's going to be preparing patent applications, so drafting patent applications, filing them at the United States Patent and Trademark Office, and then working them through the examination process. That's what patent prosecution is. I tend not to use that term because it's easily confused. Like I said, a lot of people think that relates to litigation or something. I do some litigation, and I work with patent litigators, but primarily my job is going to be planning patent portfolios, drafting patent applications, and filing them at the USPTO. Now, an important thing to understand about patent attorneys is they have to have a technical background. My background is in biochemistry and molecular biology. I also have a master's in electrical engineering. So I do a lot of stuff in the computer realm. I do a lot of robotics, a lot of mechanical devices, consumer products, a little bit of everything. I have to understand the technology as well, if not better, than my clients. That's why patent attorneys are going to have this technical background. Okay, so let's start off with the four types of intellectual property, which are patents, copyrights, trademarks, and trade secrets. Now, patents is going to be the focus of this video, but it's important to understand sort of where patents fit in with the other types of IP or intellectual property. So patents versus copyrights. So copyrights are going to cover all sorts of artistic works. So things like books, movies, paintings, musical works like songs, artistic works like sculpture. All those are going to be covered by copyright, and that's in stark contrast to patents which cover useful articles. There's a wide variety of things that are considered useful articles that are covered by patents. And a lot of times, it's not always intuitive. Like, for instance, things like clothing. Clothing is, obviously a very artistic thing, but the law considers clothing to be a useful article, and so design of clothing is covered by patents. Other examples are things like computer technology, biotechnology, consumer products, pharmaceuticals, and we'll kind of go over some more of the things that are covered by patents. But the main thing is, patents and copyrights are sort of diametrically opposed. Patents cover useful things, utilitarian things, and copyrights cover artistic things. And then there's copyright. So copyrights are going to cover logos, it's going to cover slogans, it's going to cover the names of businesses, the names of products. And trademarks are intimately associated with goods and services. That's the most important thing to understand about trademarks. So it's not just you can get a trademark in general on a slogan or a name. It's intimately associated with specific goods or services related to that mark, whether it's going to be a name, whether it's a logo, whether it's a slogan. Okay, now the fourth type of intellectual property is trade secrets. So trade secrets, really anything that can be held in secret that isn't publicly known, things like formulas, recipes, processes, client lists, and when you're developing technology sort of in the early stages before you've made it public, a lot of those things can be covered by trade secret. So those are the four types of intellectual property. So let's turn to patents then and focus on those. So what is the basic right of a patent? So it's you have the right to exclude others from making, using, selling, offering to sell, or selling the invention throughout the United States, or importing the invention into the United States. And it's important to note that you don't actually have a right to do something specifically. It's actually a negative right. So like I said, it's the right to exclude others from making, using, selling. Okay, so to give you an example, so for instance, like let's say you get a patent on a drug that is used for treating cancer. Okay, so you have a patent on that. Sure, you could exclude others from making, using, selling, offering to sell maybe that drug, or performing the process of treating folks with that drug, but it doesn't give you the right to actually do that. So to be able to actually treat people, with that drug, you actually have to approve from the FDA, right? So that's a good example of why patents don't actually give you the right to do anything. They give you an exclusionary right to stop others from making, using, selling, offering to sell. And so, along with, the patent rights, this ends up not being really the most important thing when it comes to patents. A lot of times people think, hey, I want to get a patent because I want to stop people from doing things. And yes, that is the basic right of patents. That is the core of what patents are. But especially for inventors and entrepreneurs and startups, that's actually surprisingly the least important part of what patents actually do for you. So yes, patents can give you a monopoly over a certain sort of claim technology for a certain period of time, typically 15, 20 years, depending on what sort of patent it is. But having a patent or a patent application, you can license that technology. That is, you can allow others to use it and maybe get royalties. Maybe get a lump sum payment, things like that. A lot of different types of licensing, as you probably already know. You can also sell patents. So for instance, you can, instead of a license where you're allowing maybe one party or multiple parties, you're giving them the right to use something and you still own the patent, you could potentially sell the patent, and patents can be quite valuable. Patents also give you a book value that can be considered value in a company. So for instance, if you have a patent portfolio of 10 patents, and let's say each one is worth $1 million, you may be able to get a loan based on the value of your patents, or maybe be able to get investment based on the value of those patents in a company. So just holding those assets can be extremely valuable for folks. But really, one of the most important things, though, is sort of the positive marketing purpose of patents. Being able to say you're patent pending, or you have a patent or patent portfolio, that's really attractive to a lot of folks. So it could be attractive to potential customers. You can say it's patent pending or it's patented technology. That differentiates you in the market and makes people say, hey, this is something special. This is a product that is different, that was awarded a United States patent. And so that's one of the things that, can set companies aside or set products, set them apart from their competitors, is being able to say that the technology is patented or patent pending. Along with that, you can attract folks like investors. Investors love patents. A lot of times, one of the main things, that's part of the deal is going to be the intellectual property, and specifically the patent portfolio. That can be important, with getting investors and exit strategies, selling to companies. Having patents is really important to that aspect as well. So, along with customers and investors, it's also really important in attracting employees. Employees will see your company, or potential employees, I should say. So potential employees, they see your company as being innovative. You're not just, creating boring technology. You're creating important stuff that's patented or that's patentable. You're cutting edge and you're innovative. And a lot of folks want to work for companies like this. They want to get patents themselves and see that as like, hey, I'm getting in on something that's going to be important for me and my career, and I'm working with a company that's doing interesting things. So aside from the positive benefit, this positive benefit for employees or potential employees, investors, folks like that, you also instill fear in competitors. And this is not, actually suing people or sending people cease and desist letters. There's a lot of benefit just by saying that you're patent pending or having published patent applications, talking about your patent portfolio, talking about patented technology. A lot of times if it's patent pending, people don't know what's patented and what's not patented. Typically it's because you're not able to look up the pending patent application. And even if folks do, a lot of times it's hard to know what is protected and what's not, especially when the application is pending. A lot of people don't realize that the claims are not set in stone when an application is pending, and that the application may not even ever issue as a patent. A lot of people are scared to get into a market when a competitor has something that's patent pending or that's patented. They have a hard time understanding what's protected, and a lot of times will just say, well, let's not get into that market, or let's not have a product that's competing. If we are going to do something, let's do something completely different. So just having the patent pending status, that ends up being one of the most important things, especially for early stage companies like inventors, entrepreneurs, and startups. And also there's the benefit of having defensive publications. So we kind of mentioned sort of the offensive benefit of patents, where you can stop people from doing things or you can scare other folks. But there's also the defensive capability. So by default, patents are held in secret for 18 months. And at 18 months, unless you file a non-publication request, the patent application will publish and it'll be publicly available. And there's a huge benefit to that because that can be used as prior art against other people trying to patent certain, similar things. And we're going to kind of go over what prior art is and the examination process later on, but I'll kind of give you the basics here so you can understand why this is so important. So for instance, in the patent examination process, typically the examiner is going to use published patent applications or issued patents as prior art against other people's patent applications. Sure, things like blog posts or your actual product could be prior art, but a lot of times patent examiners aren't going to take the time to find that sort of prior art. And I've seen this a lot. I've done litigation like this where folks have been selling a product or they've been working on this technology and they didn't patent it themselves, but somebody else went out there, came up with something similar and patented it such that it actually covered what their product was. And what ended up happening is that the patent examiner didn't know about the previous products, or maybe the products were held in secret or something, and so somebody else patented something that covered their product. Had they filed a patent application and had it published, the patent examiner would have likely found that, used that against the other person who ended up getting the patent, and would have stopped the issues like being, this company being sued for infringement. So there's a lot of defensive benefit to filing patent application, and that's true even if the patent application is pending, and honestly, even if the patent application never issues as a patent. So for instance, if it publishes, that's prior art forever. That's always publicly available, and that prior art can be used against folks even if it's a pending application and examination is still going on, or even if you decide to let the application go abandoned and it never issues as a patent. So that's something that a lot of folks don't think of either, is that you solve a lot of problems by just having your patent application publish. And a good way to think about patent protection, it's kind of like an arms race that, if you have a competitor and they have patents, it's good to file your own patent applications, because if you have some patented technology, you can potentially use that against them and maybe some of their products if they happen to accuse you of patent infringement. And a lot of times it doesn't come to lawsuits. A lot of times, these companies will cross-license things or come to some sort of agreement or decide to leave each other alone, knowing that, well, it's going to be a nuclear option. We both have big patent portfolios, and if one of us sues the other one, hey, then there's going to be cross suits for patent infringement, and this is going to get expensive. There's no benefit in doing that. So either let's come to some agreement and cross-license things, or let's decide to work together and just sort of leave each other alone and work in different spaces. So what are the requirements to get a patent? And there's really 4 main requirements. One is it has to be patentable subject matter. And so what that kind of means is, so it has to be the thing that can be patentable or is eligible for being patented. So for instance, if you come up with a new song, or if you write a book, well, that's going to be the subject of copyright. And so that kind of thing is not going to be patentable. But let's say you come up with some software, or you come up with a new consumer product, hey, that's the kind of thing that can be patented. And so, that ticks the box for being a patentable subject matter. Second thing is that it has to be adequately described in the patent application. And the big mistake that a lot of folks make, especially when filing provisional patent applications, and we'll get into provisional versus non-provisional patent applications in a bit, is that people don't provide adequate description. And so there's not an enabling disclosure of the technology. So the requirement is that you must describe the technology in sufficient detail such that the average person in the art, your average person who kind of works in the field, they can make and use the invention just based off of your description and maybe the drawings that you provide. And that's the problem that a lot of folks, if they do it themselves, that they run afoul of, is that they'll just say, file an abstract, or file a 1-line or 2-line patent application saying, well, this kind of describes what I'm doing. Well, it's not an enabling disclosure. And then what ends up happening is people have worthless protection, or the patent application will totally die in the examination process because it's not fully enabled. Okay, so a lot of times those things are pretty easy to deal with when you're working with a patent attorney. Those don't tend to be issues, but the next 2 substantive aspects of patentability are that the claim technology is new and non-obvious. Okay, and so let's talk about those 2 things. So new is, the question is there one piece of prior art out there, whether that's, say, a scientific paper or an existing product, a pending patent application that published, an issued patent application, it could be a YouTube video, a blog post. Is there one technology disclosure that describes everything you have claimed for your invention? And a lot of times, there's going to be something different between your invention and somebody else's. A lot of times, people aren't going to describe the exact same thing. And usually the novelty requirement, that can usually be fairly easy to go over. What the difficult standard is that the technology must be non-obvious. So non-obviousness is a requirement that, in view of all known prior art, and we kind of I mentioned kind of what prior art is, knowing all of the prior art that exists, like I said, whether it's issued patents, published patent applications, YouTube videos, existing products, all that, would it be obvious to come to your claimed invention given everything that's already known? And the way that it sort of practically works in the examination process, the examiner sort of takes elements from these different pieces of prior art and combines them and says, well, okay, one single piece of prior art, it doesn't disclose all of these things, but if you kind of pull some stuff from here, if you pull some stuff from here, and you pull some stuff from here, you can come to your invention. And your invention is obvious, and so that's where obviousness rejections come from. So those are the 4 requirements of patentability. So again, it has to be patentable subject matter. It can't be something that's not patentable, like, say, books, or it can't be a logo, things like that. That would be copyright or trademark. It has to be adequately described. You have to have a full description of the technology. And a lot of times, this is going to be, I work on applications all the time that are going to be, 100 pages or more. That's not atypical. Usually these are very detailed descriptions. Like I said earlier, I have a technical background. I have to write very detailed technical descriptions of stuff. engineers and scientists would understand. And then the claimed invention has to be new and non-obvious. Okay, so let's kind of talk about some issues when inventing and developing technology, sort of the early stages of things. And this is going to be something important, and kind of, for the attorneys out there, if you're going to be counseling clients, you want to be thinking about these things in early stages. A lot of times the client is going to come to you and say, hey, I have this business, or, I'm thinking about this product. These are the things you want to be thinking about in terms of patent issues, and stuff that you can kind of give them basic counseling on, and stuff that you probably want to refer off to a patent attorney who's kind of a specialist in these things. So one of the most important things is that patent rights start to be lost upon a first public disclosure, public use, or offer for sale of the technology. And this is one thing that people make mistakes on all the time, is that they launch the product, they've been selling for, and they're like, this is great, I should patent this, but they've been selling for over a year, and so they've forfeited their patent rights in the United States. And upon the first public disclosure, public use, or offers for sale, they forfeited their rights in foreign countries. And that's kind of the important thing to understand, is that so the U.S. gives you a 1-year grace period. So in the U.S., you have 1 year from your first public disclosure, public use, or offer for sale to file a patent application. Otherwise, you lose your patent rights. Effectively, the technology becomes dedicated to the public. But in pretty much any foreign jurisdiction, you're automatically going to lose your rights upon a first public disclosure, public use, or offer for sale. And that's why best practice is to file a patent application before you do any public disclosures, public uses, or offers for sale. And that's something you should kind of counsel clients on, is, hey, before you make any public disclosures, be sure to file a patent application. As I'll kind of discuss later on, typically it's going to be most cost effective and time effective as well to file what's called a provisional patent application. Another thing, and like I said, you want to file before a first public disclosure, public use, or offer for sale. But another event that is kind of important to file a patent application before is before talking with investors. Now, a lot of times when you talk with investors, this isn't going to be considered a public disclosure, public use, or offer for sale. These are at least implied confidentiality situations. But at the same time, it's pretty important to file a patent application before talking to investors, just because of kind of the practicalities of things. So one of the issues is you want to be able to go into the meeting, and it helps your pitch to be able to say, hey, the technology is patent pending, right? It really helps the pitch, and being able to be open about what the technology is. Anybody who works in the startup space knows that people who are asking investors to sign non-disclosure agreements, investors are not going to want to do it. They're going to be insulted, and they're going to see you as being a newbie, and you're probably going to be rejected as a result. So the better thing to do is file a patent application, go in, say you're patent pending, be friendly about it. Don't, get in somebody's face, say, hey, I'm patent pending, don't mess with me and my idea, right? Be friendly about it. But use that instead of having people sign non-disclosure agreements. That's a far better way to handle things. And so that's why I typically say, file a patent application before talking to investors. It really improves the pitch and allows you to go in and talk freely about the invention, because you have a priority date before you talk to the investors. And so you're protected before talking to them. Okay, so another thing to note when developing things in kind of the early stage is the United States is no longer a first to invent system. So back in 2013, we came to parity with the rest of the world, where priority is given to the person who files a patent application first, not the person who invents first. The way it used to work was, if you could show that you invented something before somebody else did, it didn't matter whether they filed their patent application first. You would get priority based on your early inventorship. But the rest of the world never worked that way. And the United States finally in 2013 decided to come to parity with the rest of the world. And so we are now a first to invent system. So that's kind of something important. So it kind of raises a couple of issues. One is you want to file as soon as practical, but you don't want to file too early. The best time to file is, like I said, is right before you're making public disclosures, public uses, or offers for sale, or before you're talking to investors. So, why is it good to wait? A lot of times, if you file too early, you're going to be setting yourself up for costs too soon. One, even if you're starting with a provisional patent application, there's a lot of cost associated with that, especially if you're going to be working with an attorney, and it's better to delay that. Two, you file a provisional and then you have to file a non-provisional a year from then, which we'll kind of talk about in a bit. And non-provisional patent applications that are done right are going to be quite expensive. So if you can wait to file your initial provisional patent application, you're also then going to delay the cost of filing that non-provisional patent application. And trust me, you file a provisional, and that year that the provisional is pending, that goes by really fast for startups. People think, oh my gosh, a year, that's so far down the road, but that goes by super fast. And a lot of times, hopefully the company is getting some more traction. Hopefully they have investors. But a lot of times, that year goes by and suddenly the company is kind of on the hook to have to file this expensive non-provisional patent application. And if they're not ready for it, it's going to be costs that they're going to have to come out of people's individual pockets, or it's going to have to come out of funds that really should be allocated to other places. Okay, so another thing that is really important to understand in the early phases is that inventors have to affirmatively assign their rights to inventions to the company. And so let me step back and kind of give you some background on that. So in a patent application, the true inventors have to be named. That's one of the requirements of a patent application. Anybody who made an inventive contribution to the subject matter has to be named in the patent application. And it's not like things like copyright, where a employer-employee relationship, a lot of times that can be considered work for hire, and so there's sort of an automatic ownership in the company. It doesn't work like that with patents. So with patents, the inventors have to affirmatively assign their rights, and typically this is going to be done in some sort of employment agreement, a contract agreement, collaboration agreement, where these inventors or potential investors sign a contract that includes a clause that says, I hereby assign any patent rights to any invention that I come up with to your company. And that should be done early on with any sort of collaboration, with any sort of employees, anybody that's really collaborating with the company. There should be an assignment clause in their contract, so that later on, if they happen to come up with inventive subject matter, then the rights are already assigned. You don't have to deal with issues of inventors not wanting to assign their rights because there's no requirement for them to do that. And I see this issue a lot where people say, yeah, we're excited, we want to file a patent application. And I say, okay, well, great. Well, where are the, I want to see the contracts that say these inventors are required to assign their rights. And they say, oh, well, we didn't do that. And so they have to go back and they talk to the inventors. And then the inventors say, oh, well, this company is starting to get traction. You're going to file patent application. There's value here. Well, I want to get paid more, or I refuse to sign. I own the rights to this, right? And that can cause a lot of problems. One, it can make it so that you really can't file the patent applications, or you have split ownership issues, and then investors hate that. That's a huge liability. Sort of those random owners who are the inventors, they can go off and they can license, they can sell, they can allow other people to make and use the technology. They can allow others to sell the technology. They can do it themselves, and you can't do anything about it. So make sure you tie up assignment rights early on. Okay, so one thing is, definitely talk to a patent attorney early in these things. So for instance, if you're not comfortable with a lot of these patent issues, a lot of times you can have a patent attorney do a free consultation for folks. I tend to give folks a free half an hour of a consultation. A lot of times you can suss out the major issues and do some kind of planning about, how and when you're going to start filing patent applications, whether things are patentable, kind of the chances of whether things are patentable. A lot of times that can be done, within a half an hour to an hour. And a lot of times patent attorneys, they're going to do those things free. So feel free to, engage with patent attorneys early. It makes a lot of sense to kind of get involved in the process, with patent attorneys as soon as possible. And even if you're not going to be filing patent applications immediately, it's good to have these things in mind, and especially if people kind of forget the issues with public disclosures and with inventorship and all that, it's good to sort of, talk those things through with the patent attorney early on. Okay, so another thing I sort of want to mention too is that there's this misconception out there, and especially online, I've seen this where people say, well, ideas or software can't be patented, and I would have to say that is completely untrue. And I've had a lot of people, kind of say, oh, well, I came up with this software, and well, I didn't patent it because, well, I know that software isn't patentable. It's like, well, it totally is. I work and I patent software day in, day out. That's the vast majority of my practice. Just like ideas, a lot of people say, well, I've heard that abstract ideas aren't patentable, and so I don't know about this idea. It seems kind of abstract. I'm just not going to patent it. So, don't make those determinations on your own. Talk to a patent attorney about your technology, especially when it comes to ideas and software. So, for instance, I'll give you an example with ideas. So, sure, there is case law that specifically says that, okay, abstract ideas aren't patentable, but that doesn't really answer the true question that folks have. Is they say, hey, I have an idea for a product, and the product would do these things, and here's how it would work. That's totally patentable as long as you can describe that in sufficient details such that the average person can make and use that idea. And what they're really asking is my concept for for this product, is that patentable? Could I file a patent application now? And the answer is yes, as long as you can provide sufficient detail. Are bare ideas patentable? No, typically not. It's going to be in the details of how things are done. But what I do with a lot of folks, especially if they don't necessarily know what they're going to do, they're early stages and we have to file a patent application, as somebody with a technical background, I can fill in those gaps for people. Like, that's something that patent attorneys do a lot of times. And a lot of times you can just kind of make stuff up. You don't have to know exactly what you're going to do. You're not held to one specific way and say, well, I have to know which specific way I'm going to do this. You can talk about all sorts of different alternatives, okay? So don't ever buy into this thing that ideas aren't patentable. And similarly with software, so the law technically says, yes, software is not patentable. But this is one of the problems with communication with attorneys especially, is they talk about these technicalities of law, but they're not really answering somebody's question. So for instance, like, I have folks coming out all the time and say, hey, I have this software for a cell phone app. Is that patentable? So, okay, yes, technically, the software itself is not patentable, but a cell phone configured to perform functions, A, B, C, and D with the method of elements A, B, C, and D, that is totally patentable. Or a method of doing something or other, having the steps of X, Y, and Z, that is patentable. Or a non-transitory computable readable medium, as in a computer memory that when executed by a processor performs steps X, Y, and Z, well, that can be patentable as well. So, okay, so, yes, you can't claim a piece of software that does X, Y, Z, but you can effectively claim software by claiming a device that, performs certain steps, a method of doing something, or the memory, a computer memory that stores instructions for doing X, Y, and Z. So that's why a lot of folks, give bad advice when it comes to saying, well, software isn't patentable. And even though that is technically correct, it's really not effectively true and doesn't really answer folks' true questions about whether their software-based product is actually patentable or not. Okay, so when it comes to patents, it's important to understand that there are two main types of patents. There are design patents and there are utility patents. So when it comes to utility patents and design patents, it's kind of a misnomer in some ways, because utility patents actually do cover designs. Utility patents cover designs of things or the physical configuration of things. Design patents cover one specific ornamental design of an article of manufacture. So here's some examples of design patents. And design patents are really, really diverse. Any useful article. So, whether it's electronics, it could be, I have the example here of there's firearms, sunglasses, a computer keyboard, figurines, things like that. Those things can be protected by design patents. And design patents cover one specific design of things. So really, it's going to be essentially just drawings, these black and white line drawings, as you can see in this example. It's going to be different views of that. That's what a design patent covers. So in contrast, a utility patent application, I'll kind of give you a sense of that as well. So utility patents cover systems, so physical things, or they can protect methods of doing things. And the big difference between design patents and utility patents is that utility patents have claims, that is, what defines the metes and bounds of protection, that's in words. And so here's a good example. So on the right side here, so you have this design patent for this weird wrench hammer thing that has a nail pry bar at the bottom. So a design patent would have different views of this and would protect this specific design. So you could potentially protect this with a utility patent application as well. So here you would have a claim that is in words, and so it would say a tool comprising a hammerhead, a wrench slot, and a first nail puller at one end of an extended shaft, and a second nail puller at a second end of the shaft. So, that's sort of a way of describing this thing in words. And the big difference here is that describing in words, there can be a lot of different shapes for that, right? So, for instance, like the hammerhead itself, like that could be square instead of being round. It could be a lot of different shapes in that. And, for instance, it could be really long, it could be really short. The nail pullers could, be sort of different shapes and sizes. A design patent is going to be very specific to this one design, whereas a utility patent can cover things a lot more, in a lot more varied way. It's just important to understand really basically there are utility patents and design patents. Again, talk to a patent attorney about what is applicable. A lot of times utility patents are going to be what you're going to want. And every once in a while, you're going to have design patents be applicable. And then sometimes too, it's going to be both. You're going to want to file both a design patent application and a utility patent. So utility patents versus design patents, they both have their pros and cons. So utility patents, like I said, they cover an idea or a product very generally. It can be very broad protection. But at the same time, it's a lot more expensive. These are the applications that tend to be, in the tens, if maybe hundreds of pages compared to design patents, which are just, some line drawings and a one page of description. For utility patents, and we'll kind of get into this patent process, it can take anywhere from 2 to 5 years or more from when you start the patent application process for patents to issue. It takes a long time for utility patent application to issue, and they're a lot more difficult. The examination process is a lot more arduous. There's a lot more back and forth with the examiner, and that's one of the things that makes it more expensive as well. Whereas design patents, a lot of times they're almost guaranteed to go through, and there's really not much of an examination process. That makes them a lot more or less expensive in terms of one, sort of the content of the application. Really, like I said, it's just line drawings and one page of description compared to, tens if not hundreds of pages of really detailed description. Design patent applications are going to be examined and issued a lot faster. A lot of times this can be within 6 to 18 months, which is a lot faster than utility applications. Like I said, design patents are going to be almost always allowed. It depends on the design. But a lot of times it's not all that difficult to get design patent applications through. So the rest of the time, I'm going to be talking about utility patent applications. And again, that's because utility patent applications are the main type of application that you're going to be filing. That's, I would say, 95% of the time, utility patent applications are what's going to be applicable. So that's going to be the discussion kind of for the rest of it. There are two ways to start the patent process, and this graphic kind of shows both of them. One is to start with what is called a non-provisional patent application, and that is the formal patent application that has all the formal requirements of very specific types of formatting and for the drawings and for the description. And tends to be a pretty expensive application. You file this application at the United States Patent and Trademarks Office, and it takes anywhere from 1 to 3 years before the examination process begins. And this is just, it's just because of the government. The government, is slow. They have a big backlog, and the backlog is essentially 1 to 3 years long. So you're just really waiting in a big long line for the patent examination process to begin. So the patent application process begins, and examination is like a negotiation. So the examiner is going to perform a prior art search and determine whether what you have claimed is new and non-obvious. And then you have a negotiation where you're trying to convince the examiner that what you have claimed is new or non-obvious, or maybe you can even amend the patent claims to define something that is new and non-obvious. Hopefully this examination is successful and a patent will issue. Okay, so that is starting with a non-provisional patent application. So the other option is to start with what is called a provisional patent application. So provisional patent application, it is just a placeholder. It only lasts for 1 year, and this is shown on the bottom here. So provisional patent application, it lasts for only 1 year. It expires the end of the year. You can't extend that term, and that's when you have to file the non-provisional patent application. And then really the process is essentially the same. So again, you have from the non-provisional, you have 1 to 3 years. Before examination begins, and then it can be, several years before the application issues, if ever, assuming the negotiation of examination is successful. So why would you choose a provisional versus a non-provisional patent application? So when it comes to startups and early stage companies, it almost always makes sense to start with a provisional patent application. And there's a lot of reasons for this. A lot of it is because the provisional patent application it's a lot less expensive. It doesn't have all the formal requirements that a non-provisional patent application does. I mean, a lot of times what I'll do is I'll have the inventors draft a detailed description and maybe provide some drawings of what the technology is, and I can then format that and edit that and file that as a provisional patent application. A lot less expensive than having to have me draft these long, maybe tens if not hundreds of pages worth of description and drawings. That tends to be a lot more expensive because there's a lot more attorney time involved in that. Also, it provides a lot of flexibility. So being able to file a provisional patent application, that protects one version of the technology at that filing date. And then at the non-provisional stage in a year, then you can add updates to that. Otherwise, if you file the non-provisional application first, and I'll kind of go back to this slide that shows the difference. If you start with a non-provisional application, if you come up with new aspects of the technology, which trust me, I mean, especially in early stage companies doing R&D and things, there's always going to be updates to the technology. That's always going to happen. Even when people say, oh, well, no, we're pretty sure that this is the final version. We're not going to be doing anything different. You get it in front of customers, you start doing R&D on stuff, and things sometimes dramatically change. And what ends up at the end of that year sometimes is completely different. Even what we filed the provisional patent application on, it doesn't at all cover what ends up being the final invention. So the benefit of filing provisional patent application is it allows you to incrementally protect things. You get to protect things at the provisional stage and then add new things at the non-provisional stage. Sometimes what we'll even do too is we'll file a first provisional patent application maybe in 6 months. Okay, you're getting it in front of customers, you're coming up with new stuff, you're doing more R&D. Investors get involved, investors say, hey, we want to add these new features. There's a lot of inventing that goes on, and we'll even file a second provisional patent application 6 months down the road. Then a year from the original provisional patent application, we'll file the non-provisional, and that'll even include more updates and more additions to it. So filing a provisional patent application is a great way to incrementally protect things. Also, like I said, it delays the expensive cost of the non-provisional patent application and the cost of the examination process. Yes, it slows things down, and that's kind of what you can see here is there's a year of extra time that doing the provisional patent application adds because of that 1 year provisional term. And a lot of people say, oh, well, that's bad because having the non-provisional, having it issue as soon as possible is good. I want to be able to enforce it right away. That's kind of counterintuitive. It's actually a lot of times better to allow things to remain pending. One of the big things is, delay the cost. You don't want to incur the cost of the non-provisional or the examination phase earlier than you absolutely need to. Delay those costs. Your budget should go to other things ideally. And having the patent in hand, okay, yes, you can say that you're patented, and that's maybe a bit more of a benefit when it comes to, say, investors or things. But a lot of times it's going to be really difficult and expensive to actually enforce things. So yeah, you have an issued patent, but then to enforce it's going to be tens, if not hundreds, or typically millions of dollars to enforce patent rights. And so yeah, maybe you get your patent issued and you get it issued quickly, but it's difficult to enforce it because you don't really have the bankroll to do that. So like I said, so for smaller companies, for early stage companies, who are inventors, entrepreneurs, startups, almost by default, I'll file that provisional patent application and then file the non-provisional a year later. Starting with the non-provisional patent application, that tends to be the strategy of larger companies. So larger companies who have hundreds of assets, thousands of assets, they tend to file non-provisional patent applications first. Okay, so what is the anatomy of a utility patent application? So okay, we have the drawings, we have what's called a specification, and then we have a section called the claims. And when people are looking to determine whether there's infringement or what is covered by a patent, they'll look at the drawings, they'll look at the description or the specification, and they'll assume that everything there is protected. But that's not really true. The claims section, which is these little weird sentences at the very end of the patent application or the issued patent, it's these weird claims sections that actually define the metes and bounds of what is actually protected. And here's a Venn diagram to kind of give you a sense of what is actually protected in patent applications and the way to think about it. So you have the big circle, and that's the specification and drawings, and a subset of that is actually the claim. So what's important here is that everything in the specification and drawings typically is not actually protected. The claims will typically cover what is a subset of the whole application. So the mistake that people make is they look at the drawings and say, oh, well, all this stuff in the drawings, this is actually covered, or read the whole description and say, okay, well, everything in this description, this is covered by the patent. That is untrue. You have to look at the claims at the end of the issued patent in order to understand what is actually protected. Now, that is not always easy to do. Okay, so the claims really influence two things. One is going to be infringement. So it's important to understand what the difference is between infringement and patentability, okay? So infringement is all about the claims of an issued and enforceable patent. So a patent application that publishes, a published patent application will have claims in it, but those claims are not enforceable yet because the application is still pending. And a lot of times, like I said earlier, a patent application published, it can go abandoned. So you may come and find a publication and the application may already be abandoned. Okay, the big mistake that people make is they look at the claims of a pending application and are scared off by those things when that patent application is actually already abandoned and those claims were never enforceable and aren't currently enforceable. So again, infringement relates to issued and enforceable patents. And the question with infringement is, does the accused product have all the elements as defined in at least one claim of the issued patent? And we're going to kind of go into that analysis in a bit. Patentability is very different. So when it comes to your product, the question of, is that product patentable? That's a question of prior art. So are the patent claims in your patent application, are they new and non-obvious compared to the prior? And we kind of talked about that earlier. So that's the big difference between patentability and infringement. People say, well, my patent application, it infringes somebody else's patent. Well, that's not really true. Your application may not be patentable in view of somebody else's prior art, which could be an issued patent, it could be a pending patent application, but that's not infringement. So a patent application cannot be infringing. Just because you have a patent application, someone cannot sue you for infringement for having a patent application that may cover some of the things in their issued patent. And a lot of times, the vast majority of what is in patent application, in the description and drawings, that's going to be prior art. That's going to be things that is well known. It's going to be background stuff, technology. So patentability it relates to the claims of your patent application, whether those are new and non-obvious over the prior art. So I've been using the term prior art a lot, and I've kind of talked about this a bit, but it's important to understand what is considered prior art. So it's anything that is a technology disclosure before you file your patent application. And so I said, in the examination process, a lot of times this is going to be issued patents which are published, patent publications of pending patent applications. That's, I would say, 95% of the time, that's the prior art you're going to see in the examination process, because that's the easiest stuff to look up. Those sort of technology disclosures have the most description, and that's why patent examiners tend to use that a lot more. But really, any technology disclosure is eligible as prior art. I mean, this can be like scientific papers, articles, whether it be in a newspaper or online. It can be books, videos, talks, actual products, product catalogs. So anything that discloses technology can be used as prior art against a patent application. Okay, so let's kind of go over the examination process. We already kind of talked about the basics of it, but I'll kind of get into some of the nitty gritty here. So like I said before, you file your non-provisional patent application at the USPTO. It waits in line for 1 to 3 years. And again, keep in mind that it's all about the claims. The claims define what the metes and bounds of the protection are or are going to be. So you've already seen this graphic, and it's sort of a good way to understand what's going on in the patent examination process. So you have the specification and drawings, which are going to discuss a bunch of stuff, and the claims are only going to be describing a subset of that. Like I said, specification and drawings, they can include prior art, things that are well known, things that totally aren't patentable. That's totally fine. A lot of times you can have multiple inventions in one application, and the claims are only going to be covering one of those inventions in any given application. So like you can see here, claims are typically a subset of the whole specification and drawings. So you file the application, the patent examiner does a prior art search and determines whether what the claims are new and non-obvious. And let's say the examiner comes up with some prior art. Here's what happens. The examiner issues what's called an office action, which defines the rejections of the, that are the results of his or her prior art search. So I'm going to give you the example here of an obviousness rejection and a novelty rejection. So the red circle, the examiner is saying, okay, well, this portion of the claims, sort of the claim, the prior art, it covers those portions of those claims. So those claims or those portions, those aren't novel over the prior art. Now, sort of the yellow section, that's going to be analogous to what is an obviousness rejection. So with those claims, the examiner is saying, okay, so I wasn't able to find one piece of prior art that talked about everything that's in these claims. Instead, I found prior art 1 and piece of prior art number 2 and combined those elements. And if you combine those two, that covers certain claims. So that's what a obviousness rejection is going to be. Okay, so you have these rejections. Oh my gosh, well, do you just give up? No, you don't. I mean, rejections are a natural part of the patent examination process. And I would say 98% of the time you're going to have rejections. Like I said, think of the examination process like a negotiation. Just like for instance, think about Pawn Stars or American Pickers. It wouldn't be a very good show and it wouldn't be very good negotiations if they said, hey, I want to sell you this for X, and there's no haggling over that, right? So just like haggling over buying something from somebody or selling something to somebody, the patent examination process is like a negotiation. The claims are kind of the same way. So, okay, how do you get over these rejections? One thing you can do is you can argue against the examiner and say, well, examiner, you didn't understand the prior art correctly. It doesn't actually cover the claims in the way that you are saying they do. Or you didn't understand the claims. The claims actually are different than the prior art as you're interpreting it. Alternatively, what you can do is you can amend the claims. So the claims, they have to be amended within the scope of the description and drawing. So for instance, let's kind of go to the next slide. So for instance, let's say you amend the claims to add new elements. Now here's some important things to note here. So I'll kind of flip between these two slides and kind of give you a sense of what's going on. So you've expanded the scope of these claims, and effectively what that is you're going to be adding new language. What's important to note is that, okay, you've added it to include things that aren't in the combination of prior art number 1 and number 2, things that aren't in prior art number 1 alone, but what you add in there has to be within the scope of the specification and drawings. If not, it's going to be considered new matter and those amendments are going to be rejected. So that's kind of an important thing to note here, is that, and that's why the claims tend to be just a subset of what is in the description. That allows you to amend the claims and add things. You can't add things that aren't already in there. So what you've done here in this example is you've amended the claims, and so those little pieces that are the new parts of the claims that aren't in the prior art, the examiner would say, oh, okay, you've added something. It's not in this one single piece of prior art. It's not in pieces of prior art number 1 or number 2. And so then the examiner can say, okay, then the application is allowed. So this is kind of the scope of what the allowed patent application would be, and the scope of the claims and the specification. And so kind of look at the beginning. So you have these claims that have less in them, and then by the end of examination, the claims have more description in them, and that was done to get over the prior art and get the application allowed. An issue fee is then paid, and then the application issues as a patent. Okay, now I want to give you some examples of how to understand claims, and that less is more with claims. So take a second to look at these 3 different claims, okay? So you have claim A, you have claim B, and claim C, okay? So I'll give you kind of a second to take a look at these. Okay, so which one do you think is going to be a better claim? If you could choose one, which claim would you choose? Would you like A, would you like B, or would you like C? The secret here is that less is more when it comes to patent claims. Claim A is actually the best one because it has the least number of elements. So the standard for infringement is whether the accused product has all the elements defined in one claim. So for instance, in claim A, you only have 3 elements, and it's a lot more easy to infringe because it doesn't take as many things in a potential competitor product for there to be infringing, compared to claim C, which has a lot of specific things. That may seem like it's good, but that's actually harder to infringe. Okay, now let me kind of give you some examples very specifically. So Okay, so let's say we have claim A, and then you have these 5 competitor products. Let's say this is the claim that you have in your product. So to do an analysis of infringement here, you compare all the elements in this claim to these products. So let's start up with the claim elements and split them into their constituent parts. So let's just arbitrarily say there's 3 claim elements here. So a vehicle comprising. So, okay, I mean, all these are vehicles, right? I mean, these are all, bicycles, quadcycles, tricycle, single wheel. So they're all vehicles, okay? So the next element is a frame. Okay, so, well, A has a frame, and yeah, it's a single frame, and the others clearly have frames as well. Now, the next element is 1 or more wheels coupled to the frame. Okay, so here, let's see. So even with the unicycle, yeah, that has 1 or more wheels. It has 1 wheel coupled to the frame, and the other ones, those clearly have a wheel coupled to the frame. So all of those are going to be infringing claim A, right? Remember, so claim A was this broadest one. Let's look at claim C. We can skip over B because it's never the middle of the road one, right? So claim C. Let's kind of look at this one. So let's say then in this one we have 1, 2, 3, 4, 5 elements in this one. Starting off with a vehicle comprising a frame. We already kind of already went over this one. So yeah, all of these are going to have a frame, right? Then let's look at the new element here. A rotatable pedal assembly coupled to the frame and including a chain. Okay, so suddenly this is where it gets interesting, all right? So if you look at A, if you look at the unicycle, well, there's not a chain in that one, right? It's coupled directly to the axle, so A isn't going to infringe. And same with B, right? It has the pedal directly to the axle, so those aren't going to be infringing. In C, D, and E, in D and E, you can see the chain in there, and in C, you can see where there's going to be a chain guard, so there's going to be a chain in that one. So here, just because of that one element not being present in A and B don't infringe. Okay, now let's look at the next element, a seat coupled to the frame. Okay, well, let's see. So only C, D, and E are left. C has a seat coupled to the frame, right? You can kind of see that. D has that, E has that. Okay, so C, D, and E, they're still all candidates for being infringing. Let's move on to the next element then. A handlebar assembly coupled to the frame. Okay, C's got a handlebar, D's got a handlebar, E's got a handlebar. Okay, so C, D, and E are still already in it. Now the next one is less than 3 wheels coupled to the frame. Okay, well, so that kind of caused a problem for D and E. D has 3 wheels, so that's not less than 3. E has 4 wheels, and that's not less than 3. So here, claim C, only the bicycle with 2 wheels actually is going to infringe that. And that's the big difference between broad claim A versus narrow claim C. It makes the difference between all of these things infringing to only one infringing. So in a patent application, then why wouldn't you just go in with the broadest claim, and go with that? Well, that's a good way to start the examination process. But a lot of times the examiner is going to come up with prior art and you're going to have to add more elements. And maybe, let's say you start off with A and maybe you get to claim C, which, doesn't infringe all of those, or maybe you get to C where it doesn't infringe that many. That's the examination process. That's the negotiation. It depends on the prior art, and that's what's going to determine whether you have a broad coverage of patent protection or whether you have a narrow coverage of patent protection. That's about it. Let me kind of summarize the takeaways here. So the first one is file before you make public disclosures, public uses, or offers for sale, or before talking with inventors. Like I said, patent rights start to be lost upon a first public disclosure, public use, or offer for sale. And it's good to file before you talk to inventors, even though patent rights don't typically start to be lost when you start talking with investors. It's a good way to be able to talk with folks without having them sign NDAs, which they're not going to want to do, and it's going to be insulting to them anyway, and being able to improve your pitch by saying things are patent pending. Also, inventors must affirmatively sign their patent rights to the company. Just being an employee, just being a contractor, does not mean that those folks have an automatic obligation to assign their patent rights to the company. There has to be a specific clause in contracts that say these folks are required to, and better yet, say, I hereby already assign my rights to any inventions that I may come up with. That is an important thing for contracts that you may be drafting with employees, collaborators, other folks that you're working with. And also, patent claims can be broad or narrow, and that's kind of what we went over in the example of those patent claims A, B, and C. the wording of the claims can define whether you have a broad patent that covers a lot of different variations, like the broad claim A that covered all those 5 versions, or maybe you have a narrow claim C that only covers 1 version. Patents are not a binary thing where it's just you have a patent or you don't. It's sort of can have a gradient or a different scope of protection. And that's important to understand when it comes to patents. Okay, and then also infringement and patentability are different. Again, infringement relates to whether the accused product reads on all elements of at least one claim of an issued and enforceable patent. Patentability is a question of, so for a pending patent application that you file, and this is going to be the non-provisional patent application, are the claims new and non-obvious over the prior art? Also, examination is like a negotiation. That's an important thing to understand, that there are going to be rejections, and if anything, that's a good part of negotiation. Just like I said, with shows like Pawn Stars or American Pickers, the reason why you start off with a low offer, for instance, when you're trying to buy a product, is because there's going to be some negotiation, and that's how you sort of work your way to a middle ground with folks. Hey, an easy way to buy something is, offer double what it's worth. Anybody's going to accept that offer. An analogy here would be for instance, going with claims that are so narrow that, the examiner is never going to be able to find any prior art that's going to be able to cover that. Sure, you're going to be able to get your patent through, but you're going to end up with claims that are so narrow that it probably isn't going to cover the product that you have, and no competitor product is ever going to be able to infringe it because it's so narrow. Okay, so that's why the negotiation of examination is so important. Also, be sure to talk with the patent attorney early. Like I said, a lot of patent attorneys are going to be able to do a free assessment. It can only take a half an hour to an hour, and that's a really easy way to sort of spot a lot of these issues early on, and to make sure that you're not accidentally forfeiting rights, and to kind of plan out protection and kind of have a sense of when these costs are coming up. A lot of times it makes sense to wait as long as you can before making public disclosures, public use, or offers for sale. And a patent attorney is going to be able to kind of help you plan those things and let you know kind of when the timing is going to be and the cost of stuff. So that's about it. Love to hear your comments down below. Let me know if you have any questions, if any of this didn't make sense, if it raised any issues for you, if you've gone through the patent examining process. I'd love to hear about that. And also be sure to subscribe for more great content on patents and startups. Again, my videos typically are a lot shorter than this one. This one is a long one, a long form video, because this is a talk that I'm giving for the King County Bar Association here in Seattle. So yeah, thanks for watching, and we'll see you again in the next video.